welcome to Crime and Court. My name is Heather, and we are talking about Idaho versus Bryan Kohberger, the Idaho 4 quadruple homicides of Madison Mogan, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin. And as you can see in today's episode, we are going to talk about the judge's rule. Judge John Judge ruled on the change of venue motion from the defense, and he's also going to ineffectively or effectively remove himself from the case in doing so because he, spoiler alert, has ruled in favor of the defense's motion. So let's read his reasonings why and see what he has to say. And then I'm going to go over a statement from the Gonzalez family, who are incredibly disappointed about John Judge's ruling today. So let's get to it. Let me shrink myself. And all right, so we are going to be reading through the order granting the defendant's motion to change venue. All right, so on January 30th, 2024, defendant Bryan C. Kohberger filed a motion for change of venue pursuant to Idaho Criminal Rule 21 in a bunch of articles and stuff, and the Constitution and the Idaho Constitution. Amendments of the amendments of the U.S. Constitution. So all of that they cited. On February 8th, the state filed an objection to Kohberger's motion. The hearing then on Kohberger's motion was originally scheduled for June 27th. Thereafter, the parties stipulated to continuing the hearing to August 29th. On July 22nd, Kohberger filed a memorandum in support of motion for change of venue with various exhibits attached. We've gone through those on my channel, and if you are interested, I can link them below if you want to read the exhibits. Actually, I'll just link you well, you can watch it too. I'll give you the link to my videos and then also to the actual document, the memorandum, because it goes over all of the information that was compiled from the survey regarding the statistics and where the media saturation was versus the population and stuff like that. So I'll give you guys a link to that. All right, so a change of venue hearing was held on August 29th. Kohberger was present and represented by Ann Taylor, Eliza Massoth, and Jay Logston. The state was represented by William Thompson Jr. and Ashley Jennings, Latah County Prosecutor's Office, and Ingrid Beatty, Jeff Nye, and the Office of the Attorney General. What? The Office of the Attorney General is also prosecuting this? That's interesting. All right. So at the hearing, defendant presented, so I guess, is this federal indictments? I'd have to look at his charges again because I don't remember. Are they federal? Is that why the AG's office is part of it? I'm assuming. All right. So at the hearing, defendant presented expert testimony from James Todd Murphy, Dr. Amani L. Aleli, say that 10 times fast, Dr. Bryan Edelman, and Dr. Veronica Dahir. The state did not call any witnesses, so they didn't contest it, or they might not have contested it, but they didn't bring any witnesses to counter argue the change of venue motion. So the court has spent many months carefully considering the legal and logistical concerns with a trial of this length and magnitude, carefully reading each submission, listening to each expert, and evaluating each party's position. And when John Judge says that he carefully evaluated these things, I actually believe him versus some other judges who, in cases that we follow, like Judge Gull and Judge Canoni, when they say those things in their filings, I don't believe it. I don't believe that they review any of the defense's stuff. They're so biased. They already know how they're going to rule. But in this case, I actually believe John Judge. So it is kind of a shame that he's no longer going to be presiding over this because I do feel like he's fair and would give the defense a lot of, he would give the defense a fair trial, and as opposed to, siding with the state a lot, as we've been seeing in certain cases previously mentioned. All right, so based upon totality of the factors, defendant's motion for change of venue is granted. So what does this mean? Well, here, first of all, let's go over the background. On November 13th, 2022, four University of Idaho students, Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin, were found deceased in Gonzalez's, Mogan, and Kernodle's off-campus off-campus home in Moscow, Idaho. The cause of the loss of life for each was ruled as a homicide. As news of the tragedy broke, media outlets from around the country descended upon Moscow. As law enforcement investigated, news stations, newspapers, and social media were flooded with stories and speculation about the homicides. That's definitely true. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho, the Latah County Prosecutor's Office, and the Idaho State Police, held press briefings to answer questions and reassure the public. Appropriately, the information released was limited to protect the integrity of the ongoing investigation. On December 30th, 2022, Kohberger was arrested and charged with the 4 counts of homicide in the first degree and 1 count burglary. Again, media outlets descended upon Moscow and news coverage quickly focused on Kohberger. It is federal because it's across state lines, isn't it? Because he lived in Washington and that just popped into my head. All right, so that same day, plus, he lives in Pennsylvania, and they had to cross state lines to go get him, and yeah, so it's got to be federal charges. All right, so that same day, an order granting or governing courthouse and courtroom conduct was entered to help alleviate any potential prejudicial photography, audio, or video recording interviews within the courthouse. The conduct order has remained in place throughout the proceedings. Based off of the, or because of the extensive media coverage from the outset of the homicides, a non-dissemination order was also quickly put into place by stipulation of the parties on January 30th, or January 3rd. So almost what? Oh, okay, just a few days later, to help protect Kohberger's right to a fair trial by an impartial jury. The non-dissemination order, as amended, has remained in place throughout the duration of this case. In an additional effort to help protect Kohberger's right to a fair trial, on November 17th, 2023, this court entered an order removing cameras from the courtroom. Since that time, the proceedings have been streamed via the court's YouTube channel, which in theory allows the public access to the proceedings while minimizing prejudicial photographs and videos focusing solely on Kohberger and his every move. Despite efforts by the parties and the court to protect the jury pool from being inundated with information that is potentially prejudicial and false, extensive media coverage by mainstream media sources such as newspapers, radio stations, and television news outlets have continued throughout the state and nationally. Additionally, and perhaps more challenging, is the ongoing spread of prejudicial misinformation, rumors, and patently false theories of the case on social media outlets such as Facebook, podcasts, and blogs. There have also been numerous television shows and documentaries, as they put in quotes. Are they saying they're not really documentaries? I don't know. He's calling them documentaries, air quote, produced about the homicides, and at least one book has already been published. The parties agree the case has generated extensive coverage by the media, internet sleuths, and others trying to capitalize on the tragedy, but disagree on how the court should attempt to remedy the issue to ensure Kohberger is tried by a fair, impartial jury. In sum, Kohberger argues that venue must be changed from Latah County to a location with a larger population that is geographically distant from where the homicides occurred. The state asserts that a larger juror pool, extensive juror questionnaires, and voir dire are sufficient remedies that will result in a fair and impartial jury in Latah. So obviously the state objects. In addition to the issue, or not obviously, but they object to everything. So yeah, they're going to object. All right, so in addition to the issue of juror prejudice resulting from extensive coverage of the homicides and Kohberger by the media and others, and the smaller population of the Latah County, the defense also asserts the trial should be moved outside of Latah County, quote, for the convenience of the parties and witnesses and in the interest of justice, end quote. The state disagrees that moving the trial would be in the interest of justice or convenient to the parties and witnesses. I agree that it's not going to be convenient because everybody's going to have to pick up and go to another county and probably stay there for however many weeks the trial takes place. But if it gives him a fair trial, it has to be done. If he cannot get a fair trial in his own county, which I believe he can't because most of the population there are work for the university or have kids in the university. So there's going to be some bias there. All right, so evidence. As noted above, at the change of venue hearing, Kohberger presented expert testimony from James Todd Murphy, Dr. Amani L. Alayli, Dr. Bryan Edelman, and Dr. Veronica DeHeer. Additionally, Kohberger submitted several exhibits depicting news stories, news clips, and social media posts for the court's review. One second. Sorry, I had a cough. And I didn't want to blow your eardrums out. All right, so additionally, Kohberger submitted several exhibits and all that. The state did not call any witnesses or submit any evidence. The court will summarize the key takeaways from the testimony offered by each of Kohberger's experts. So at the hearing on August 29th, this is what the witnesses had testified to. So number one, James Todd Murphy. James Todd Murphy is the president of TrueScope North America. TrueScope provides media monitoring services that offer information to help understand the impact of media coverage on a particular community. TrueScope looks only at mainstream media sources such as newspapers and news stations. Of the mainstream media coverage in Idaho of the case, 36% of that coverage has been within Latah County. This would include media like the Moscow Pullman Daily News, Lewiston Tribune, and the television news station out of Spokane, Washington. Kohberger requests this case be moved to Ada County, which has 34% of the mainstream media coverage in Idaho. While the media coverage percentages are similar between the two counties, Ada County has a much larger population than Latah County. According to Murphy, this means that the media coverage in Ada County is much more diluted, while Latah County is saturated with such coverage. Stated differently, media coverage in Latah County offered twice as many opportunities to be seen per person than in Ada County. So that's a pretty big deal. I mean, when you say it in those terms. The higher volume of coverage in Latah County, coupled with the smaller pool of eligible jurors, means people in Latah County had twice as many chances to be exposed to this case versus those residing in Ada County. When looking at the volume of media coverage over time, Ada County had a higher volume of media coverage from February 2023 to June 2023. However, since that time, Latah County has consistently had the higher volume of media coverage, with the two counties being similar overall in their current coverage of the case. So they've had the same amount of coverage, but the saturation is more and the opportunities are more in Latah. All of this taken together means that the probability of the Latah County resident Being exposed to media coverage of the case is much higher than the probability of an Ada County resident being exposed to media coverage of the case. Number two, Dr. Amani L. Aleli. Dr. Amani L. Aleli is a social psychologist and social cognition researcher. As part of her research, Dr. L. Aleli evaluates how publicity about a case can shape potential jurors' attitudes. Dr. L. Aleli has found that the more publicity a case generates, the more likely potential jurors are to dislike the defendant and view that defendant as guilty. Dr. El Aleli believes that the publicity Latah County residents have been exposed to makes them biased against Kohberger for several reasons, even if that bias is subconscious. First, Latah County authority figures have publicly spoken about Kohberger's guilt in absolute terms. The former Moscow Police Department Chief James Fry, who was the police chief during the investigation into the homicides, publicly declared that he had no doubts that the quote unquote right guy had been arrested for the crimes. After Kohberger's arrest, the University of Idaho president Scott Green stated publicly that the university community once again felt safe. So, meaning they were unsafe, but now they're safe because the thing that was unsafe has been caught, is what they're implying there. So, generally speaking, individuals are more likely to trust and believe authority figures, especially officers. So, these statements by Latah County authority figures are particularly impactful to Latah County residents. Second, because Latah County is a small, close knit community, community members feel a sense of loyalty to community views and fellow community members. So, they basically have each other's backs. If my friend Jane Doe over there hates John Smith, I'm going to hate John Smith too because we're going to be angry at John Smith together because there's comfort in that unity and we unite to hate him. That's what a lot of people do online, and as you can see, and if you go to Twitter or X or Reddit and listen to how some of these people are just like, he's guilty. And like, you don't know that. You don't even have all the evidence at this point. We don't even know how he's connected to the crimes at this point, other than a possibly junk science or illegally obtained fingerprint, which could have been touch DNA, or which is touch DNA, and was so minute and minuscule that how do we even know that when they collected the sample, they got the right sampling, or they have, because they always have to like replicate the sample to make it bigger or whatever, however they do that in the DNA labs. And how do we know that that's accurate? How do we know these tests are accurate? We know that there's inaccuracies when people touch, the people within the chain of custody touch things, or, they touch their face while their gloves are on, and then they go back and touch the thing, or they talk over it, and their DNA somehow gets in the sample, and now it's contaminated. So, how do we know that that sample wasn't contaminated? We don't even know that because they can't give us those records. So, it's infuriating. It's like, how did we get here? But, anyways, I digress. So, for example, Latah County jurors may feel an inner clash or conflict if they felt that the state had not proven Kohberger's guilty beyond a reasonable doubt, because they may feel voting not guilty would cause community outrage. So, that's one thing. They don't want the community to be mad at them if they set a guilty person free, or once again, cause fear within the community. Thus, the inner clash may cause jurors to vote guilty even when they believe that there is reasonable doubt as to his guilt. The inner clash may be even greater with personal connections within Latah County, as considered, like my neighbor who is a police officer may be upset with me if I don't vote guilty, etc., etc. There's a number of uh, examples. my best friend who believes in Kohberger's guilt. If I don't vote guilty and I'm on this jury, I'm going to be given an earful. Well, that's fine and dandy and all, but then if there is reasonable doubt and you vote guilty based on your own personal bias, you're sending someone to prison forever. He's never getting out. He might even get executed for this. And you have to be sure that there's no reasonable doubt before you do that. So, these are some good arguments as to not getting a fair trial. All right, so similarly, given the small size of Latah County residents had a much more emotional experience surrounding the homicides and therefore are much more invested in the case. For example, when Kohberger was arrested, Latah County residents who had been fearful experienced a sense of relief, which equates to believing Kohberger is guilty. Next, the extensive negative publicity surrounding Kohberger leads potential jurors to think of Kohberger negatively. Well, yes, because most of the publicity is negative and coming from mainstream media, which a lot of time gets their sources from law enforcement. And the defense, in this case, is gagged. They can't defend him in the media. The lawyers for Kohberger can't say, hey, my client's innocent. I mean, she's been able to say it in hearings, but she can't go to the media and say, my client's innocent and this is why we know this, blah, blah, blah. She can't do that because gag order. But yet, law enforcement could go and, spread whatever they wanted in the beginning, whether it was true or not. Whether they were, I mean, they cite things as fact, like this man is guilty, even though they might not have the smoking gun that they think they do. So they speak in terms of absolutes where it's up to the jury to decide absolutely what the truth is. So that's a problem because that gets communicated to media that way, and that's how society hears it. So anyways, all right, so next, the extensive negative publicity. Stated differently, before Kohberger's arrest, if one was to hear the name Bryan Kohberger, the reaction would have been neutral. Now, after Kohberger's name and picture have been associated with the terms like all of these things that I'm not going to say, I'll say stalker and evil, but other terms referring to someone who takes others' lives. When individuals hear the name, those names, they hear it has a negative connotation. So it's obviously a negative association with Bryan Kohberger now. So the impact is greater in Latah County because of the saturation of the extensive media coverage. Finally, given all of this, Dr. L. Aleli opined that it was arguably impossible for residents of Latah County to be asked to serve as impartial jurors because they are biased against Kohberger, even if they do not want to be biased or think that they are biased. So basically asking them the question, are you biased against Kohberger? And they say no, they might literally think that they aren't, or they might give the answer that, they think that the court wants to hear, but they could still be biased and that could still be influencing their decision. So, this is particularly difficult for the defense to overcome because when humans process information while experiencing emotions like fear and anger, it is difficult to change the initial opinions formed even in the face of contradictory evidence. So, this is a good example of if you've been following the Karen Reed trial and how the family of Officer John O'Keefe firmly and vehemently believes that Karen Reed is guilty, even though they sat through an entire trial of basically the Commonwealth gaslighting them and telling them to believe that, the earth is flat when clearly it's not. So this is, that fear, anger, being angry at that person. So for example, I'm just saying, if the O'Keefe family, if they are feeling really, really angry and still can't process past that emotion of anger and they direct that towards Karen Reed, well, it's just gonna set them more firmly and deeply into their belief that she's guilty, even if they are proven in a court of law that she's not. So it's just a good example that we have in a recent case that I wanted to share. All right, so instead, we as humans pay greater attention to information that backs up our initial preconceived ideas and opinions. So when they look at the testimony and the evidence, they're looking at all the little things in the testimony that make Karen Reed guilty or that make her look guilty. And they totally uh, discount anything that contradicts that. All right, so taken together, Dr. L. O'Leary stated in her expert opinion the best way to ensure Kohberger is tried by a fair and impartial jury is to find jurors who are both physically and psychologically removed from Latah County. All right, so that's a good summary there of her testimony. Dr. Bryan Edelman is a social psychologist who works as a trial consultant for jury selection and pretrial research. In this case, the defense hired Dr. Edelman to conduct a survey of Latah County residents, Ada County residents, Canyon County residents, and Bannock County residents to determine if a change of venue motion was warranted. The key findings from the survey show that case recognition is high throughout Idaho. 98% of survey respondents in Latah County recognized the case, and 93% of survey respondents in Ada County recognized the case. So, similar there, 90% of respondents in Canyon County recognized the case, and 84% of respondents in Bannock County. So in Latah County, of the 98% of respondents that recognized the case, 67% reported that they believe they already think he's guilty. 24.7% reported that they believe Kohberger is not just guilty, but definitely guilty. So there's that. That's, I mean, those are pretty significant numbers there. Out of that 98% of respondents that recognize the case, almost 70% think that he's already guilty, with 25% thinking he's definitely guilty. So, I mean, that is a lot. Similarly, in Ada County, 68% of respondents who recognize the case believe Kohberger is guilty. 22% reported that he is definitely guilty. So, almost similar, but again, it's the saturation, the amount of people and the number of times that they see the media being shoved in their face about this guilty guy. So 69% of residents in Canyon County believe Kohberger is guilty. 23% reported he's definitely guilty. And 76% of respondents in Bannock County believe he's guilty, with 19 reporting that he's definitely guilty. The difference, though, with these Bannock and Canyon counties is that they're still smaller counties, whereas you go to Ada counties like over 300,000 um, r- uh, residents versus I think 100,000 in Latah or something along those lines. So it's pretty significant regarding the saturation of media. All right, in Latah County, 51.5% of respondents who recognized the case felt that the D penalty was the appropriate punishment, and 23.5. Hold on, dogs are yelling at each other. All right, one of my dogs was trying to walk past the other dog, and she doesn't like it if any of the dogs touch her. So she like kind of snaps at them, not in like a mean way, but she's like, "Get off me." Anyways, all right. So in Latah County, 51% of respondents who recognized the case felt that the D penalty was appropriate punishment. 23.5% felt that life without parole would be appropriate. In Ada County, 49% reported they believed that being executed was the appropriate sentence, whereas 57% in Canyon said that, and 53% in Bannock said that. All right. In Latah County, 29% of survey respondents reported following the case very closely, and 38.5% reported following the case somewhat closely. In Ada County, 58% of respondents reported following the case very closely or somewhat closely, while that number fell to 51% in Canyon and 46% in Bannock County. 39% of respondents in Latah County indicated that they experienced high levels of stress, anxiety, or fear during the search for the person responsible for the homicides. This contrasts with the 17% of Ada County respondents who answered yes to that question. So 39% versus 17%. 11% of Canyon County respondents who answered yes, and 11% of Bannock County respondents who answered yes. So that also goes back to the if you have an emotion like fear or anger, in this case fear, stress, anxiety, fear of it could come to your neighborhood, um, and that person's still out there, that's going to, once you see like, oh, law enforcement got the guy, okay, great, you're, that fear you still had, you're going to project that now to that person and be like, yeah, now I'm angry at that guy, so you're going to think he's guilty psychologically. Like, that's just what our brains do for some reason. All right, so additionally, a higher number of Latah County residents reported talking about the case with others living in Moscow when the homicides occurred, having ties to the University of Idaho, and having ties to law enforcement who investigated the crimes. Finally, Dr. Edelman considered the population sizes of the counties surveyed with Ada. Okay, so 400, sorry, I was way off. 406 thousand residents in Ada. Canyon County has 184,000, and Bannock County has 66,000 or 67, and then Latah County has 32,000 residents. So that is a big difference. I was way off. It's 406,000 residents in Ada and 32,000 residents in Latah. Huge difference. Based on all the information obtained from the surveys, Dr. Edelman opined that case recognition and presumption of guilt is and will continue to be high throughout Idaho given the extensive media coverage the case has generated. So there's going to be bias all across the state, is what she's saying. However, or he, this is Bryan Edelman at this time talking. So there's still going to be bias across the state, but the way that it is, it's the population size and the way that it's saturated that you're going to find a lot of people, you'll be able to find more people in the voir dire process that haven't heard of the case or don't have an opinion as to his guilt one way or another. So in Dr. Edelman's opinion, population size matters. For example, if roughly 50% of Latah County residents presume Kohberger is guilty, that leaves approximately 15,000 Latah residents who do not hold this presumption. Of those, not all are eligible to serve as a juror. In contrast, if 50% of Ada County residents presume Kohberger is guilty, that leaves 200,000 residents who do not hold such a presumption. So that's a good way to put it. Thank you, Judge. Thus, Ada County has a much larger pool of non-biased potential jurors. So broken down like that, it's 200,000 versus 15,000, which is still a big difference there. All right, so even more important to Dr. Edelman, though, was the issue of personal connections within the Latah County and the personal impact that this case has had on Latah County residents. The feelings of fear, stress, and anxiety surrounding the homicides were significantly greater in Latah County than in the other counties. This was also true for the connections to the University of Idaho and local law enforcement. Dr. Edelman testified that these connections and experiences are the real issue when it comes to seating an impartial jury in Latah County. Based on the results of his surveys, Dr. Edelman opined that in his expert opinion, there is a reasonable likelihood The presumption of guilt prevails in Latah County and that a change of venue is appropriate. Dr. Veronica Dehar was called, she's finally the fourth one, I believe, or the last one, was called by the defense to offer her expert opinion as to the validity of the survey work done by Dr. Edelman in this case. Dr. Dehar testified that the surveys were conducted in accordance with applicable standards and the results are sound. Okay, great. Lastly, media articles and video clips. The defense also submitted numerous media articles and video clips demonstrating the sheer number or the sheer volume of coverage that this case has generated. The court agrees that the state does not dispute that coverage on this case by both mainstream media and social media outlets has been extensive in Latah County, throughout Idaho, and nationally. While some of the mainstream reporting has been appropriate and based on information from the court record, there has been extensive coverage that is prejudicial to Kohberger and likely inadmissible at trial. Very much so. Um, Even the survey, like some of the questions on the survey, there were things on there that wouldn't have been admissible at trial, but it's like, did you hear that? Because we need to know if you heard these inadmissible things that may or may not be true. Anyways, so both the Idaho Constitution and the U.S. Constitution protect a defendant's right to a fair trial by an impartial jury. To help achieve a constitutionally sound trial, Idaho Criminal Rule 21 allows transfer of a case for trial in certain instances. Idaho Criminal Rule 21A states that on motion of either party, the court must transfer the proceedings to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Similarly, Idaho Code states that a criminal action prosecuted by indictment may be removed from the court in which it is pending on the application of the defendant on the ground that a fair and impartial trial cannot be had in the county where the indictment is pending. Idaho Criminal Rule 21 also allows a transfer for convenience. On motion of the defendant, the court may transfer the proceeding to another county for the convenience of parties and witnesses and in the interest of justice. A motion for change of venue pursuant to Idaho Criminal Rule 21 is left to the discretion of the trial court. Analysis. This is Judge's analysis now. So, in deciding motion for change of venue, the court determines whether, in the totality of circumstances, juror exposure to pretrial publicity will result in the trial that is not fundamentally fair. The critical inquiry is whether the nature of their exposure to pretrial publicity caused the prospective juror to form an opinion about the defendant's guilt, and as a result, they are unable to serve as an unbiased juror. In determining whether a criminal defendant actually received a fair trial, the Idaho Supreme Court considers the following factors. 1. The existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place. 2. The testimony of the jurors at jury selection regarding whether they had formed an opinion based upon adverse pretrial publicity. So this would be if you were already in the process of jury selection, but since they are not at that point and they're filing for this, I don't think that applies. So whether the defendant challenged for cause, number 3, whether the defendant challenged for cause any of the jurors finally selected. 4, the nature and content of the pretrial publicity, and 5, the amount of time elapsed between the pretrial publicity and the trial. Some of these factors can only be evaluated during or after jury selection, while others can be evaluated by the trial court in deciding an earlier motion to change venue. Actual prejudice. In evaluating actual juror prejudice, the relevant question is not whether the community remembered the case, but whether the jurors at trial had such fixed opinions that they would not judge impartially the guilt of the defendant. Stated differently, courts must evaluate whether, in the totality of the existing circumstances, juror exposure to pretrial publicity resulted in a trial that was not fundamentally fair. The defendant bears the burden of proving prejudice or showing a reasonable likelihood that there was prejudice. In reviewing case law, a finding of actual juror prejudice rests on an examination of the jury selection process. This includes evaluating how jurors answered screening questionnaires, the testimony during voir dire of the veneer as a whole, and the jurors. Can you sit down, please? And the jurors eventually seated, and any jurors seated despite a for cause challenge by the defense. So, in reviewing a trial court's decision denying a change of venue motion, the Idaho Supreme Court considers the testimony of the jurors at jury selection regarding whether they had formed an opinion based upon adverse pretrial publicity, whether the defendant challenged for some. Blah, blah, blah. My mouth's getting dry and I'm getting tired. Whether the defendant challenged for cause any of the jurors finally selected. So again, that has to do with jury selection, which they're not in the process of doing at this point. These factors are considered along with evaluating the pretrial publicity itself and the timing of the publicity. Here, the defense argues that the survey work of Dr. Edelman establishes actual prejudice within Latah County. However, actual prejudice cannot be evaluated at this juncture based on a survey on some 400 Latah County residents who are anonymous, did not answer questions in court, and were not subject to questioning by the state. Without attempting to seat a jury, there is no real evidence such as juror screening questionnaires and testimony during voir dire for this court to evaluate actual prejudice. Presumed prejudice. I mean, it makes sense. They're not in the process. He can't evaluate that at this time. So presumed prejudice, adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. However, a presumption of prejudice attends only the extreme case, and juror exposure to news accounts of the crime alone does not presumptively deprive the defendant of due process. Publicity by itself does not require a change of venue. Indeed, prominence does not necessarily produce prejudice, and juror impartiality does not require ignorance. Unlike the actual prejudice, a finding of presumed prejudice means that the court need not consider juror screening questionnaires or testimony during voir dire before declaring a jury verdict void or, in the case, declaring a change of venue appropriate based on prejudice. It is the defendant's burden to establish a reasonable likelihood prejudicial news coverage prevented or will prevent a fair trial in violation of the Sixth Amendment to the United States Constitution. This is not an unreasonably high hurdle for a defendant to clear. In cases where juror prejudice has been presumed, the following factors have been examined. 1. The size and characteristics of the community in which the crime occurred. 2. Whether news stories contained a confession or other blatantly prejudicial information of the type readers or viewers could not reasonably be expected to shut from sight. 3. The lapse of time between the prejudicial news coverage and the trial. And 4. With what the jury actually found as far as guilt is concerned, i.e., was the defendant acquitted for some charges, as in also Karen Reed. She was acquitted, but not in court because Bev's confusing jury instructions and apparently a foreman who wouldn't ask a question on how to treat a split verdict. But anyways, so in Idaho, courts consider 1. The existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place. 2. The nature and content of the pretrial publicity. And 3. The amount of time elapsed between the pretrial publicity and the trial. When reviewing the nature and content of the pretrial publicity, the trial court should be concerned with the accuracy of the pretrial publicity, So, whether it's accurate or not, the extent in which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, and the number of articles, and whether the jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. So, for instance, I know there was like some lady who said, "Oh, yeah, he offered to put in security cameras in my house." And so now she thinks he was watching her or something. And we don't even know who that lady is. Nobody's verified it. Like it's been out there, a rumor going on in the internet forever. And who said it? Is it verified? Like these things would never come into court, but yet it's in the court of public opinion. And they all think that that's the case, that he put in security cameras and like watched some lady because that's what they've heard. So just and that you might not have heard from mainstream media, and it might not even occur to you that you saw that somewhere on like somebody's post or something, and then you take that bias perception into jury selection or jury um, deliberations with you, and you find him guilty, even though it had nothing to do with the case. And this woman may just be a Looney Tune who went to National Enquirer saying, "I knew Bryan Kohberger." We don't know any of things that have come out to be accurate. All right, so first, as to the size and characteristics of the community, Latah County is a relatively small community with a population of approximately 41,000. 24,000 aren't eligible to serve on a jury. The state argues that this is enough to impanel 18 impartial individuals. The defense argues that the small, tight knit community makes it impossible to find impartial individuals because of the extensive publicity Latah County residents have been exposed to, the emotional experience and feelings of fear that residents experienced in the wake of the homicides, feelings of loyalty to the community, and community connections. The defense's position is supported by the testimony of Todd Murphy, Dr. L. Aleli, and Dr. Edelman. As Mr. Murphy testified, 36% of all mainstream news coverage of this case throughout Idaho has been in Latah County. This, coupled with the smaller population in Latah County, makes the probability of Latah County residents' exposure to such coverage higher than in Ada County, Bannock County, or Canyon County. Dr. L. Aleli testified that the more publicity one is exposed to, the more likely an individual is to dislike Kohberger and view him as guilty. While Dr. Edelman's survey results suggest that similar percentages of survey respondents throughout the county surveyed knew that of the case and presumed Kohberger was guilty, the sheer number of individuals in the larger counties increase the chances of impaneling a fair and impartial jury. Further, Dr. Ella Laley and Dr. Edelman expressed great concern over the emotional experiences, feelings of fear, and personal connections of Latah County residents. These issues are unique to Latah County and exacerbated by the small size of the community. Potential jurors in Ada County, for example, did not experience the same level of fear caused by the homicides as Latah County residents. Similarly, it is far more likely for jurors in Latah County to know someone involved in the investigation of the case or otherwise related to the case, and more likely that Latah County residents have discussed that case with each other. So that is very likely. Additionally, the smaller community makes it more difficult to keep the identity of jurors private, which, as Dr. El Halali testified to, may hinder some jurors in their decision making because of feelings of loyalty to the community or fear of retaliation as well. So, next, as discussed above, it is undisputed that there has been significant media coverage in this case throughout the state and nationally. While some of the coverage has been neutral reporting of the court proceedings, much of the coverage has been sensationalized and prejudicial to Kohberger. By way of example, the defense provided the court with 1,222 pages of news articles covering the case from one local newspaper. One article published after Kohberger's arrest includes statements from Washington State University students who reported feeling weird having sat in class with Kohberger and felt relieved knowing that Kohberger had been arrested. Another article states out or starts out by referring to Kohberger as the man accused of slaughtering four University of Idaho students. The title of yet another article refers to Kohberger as the UIKILLer. While the issue of extensive sensationalized coverage is not unique to Latah County, it is potentially more impactful given the volume of coverage coupled with the smaller population. As to the lapse of time between the coverage and trial, the information provided by Mr. Murphy demonstrates that coverage has overall waned since February 2023. However, there is an uptick in coverage before and after proceedings and court decisions. This is especially true for Latah County, with Ada County following a similar trajectory. The court does not anticipate this trend will change leading up to trial and anticipates the coverage will substantially increase in the weeks or in the days and probably weeks before. Finally, while this court does not have affidavits demonstrating prejudice in Latah County and the court must consider the results of the survey Dr. Edelman prepared. Again, while the presumption of guilt was similar across all the counties surveyed, the number is more impactful in Latah County given the smaller population, and it has the smallest of all of the counties of populations. Some 67% of Latah County survey respondents reported believing Kohberger is guilty, with 51% of those indicating it would be hard for Kohberger to convince them of his innocence, which, by the way, my friends, that is not what he is supposed to do at trial. He is presumed innocent up until and if a jury of his peers convicts him. He is still considered innocent. And these people are saying, prove to me that he's innocent. That's not how our justice system works. But that's how people nowadays view it. That's how the media portrays it. The law enforcement arrests the guy. Obviously, that's our guy. So the media portrays it as that's our guy. He's the one. But there are so many times where it's not the guy. And we're all fed a bunch of BS by media. And this stuff has to change. We need to be able to put aside our feelings and say, hey, I can go into this open minded and not put blame and guilt and innocence on him up until he is convicted, he's not guilty. So that is what we're supposed to do. What we do is not the same. All right, hold on one second. Sorry, needed to refill my water. All right, so continuing on. While the survey percentage answered these questions the same in Ada, the impact depends on the size, the population size, which is drastically different. Latah County has approximately 24,000 residents who are eligible for service. If 50% of those are disqualified for having fixed opinions as to Kohberger's guilt, only 12,000 remains. This is before any have been excused for hardships such as illness, breastfeeding, loss of wages for a 3-month-long trial, which there's going to be problems finding people just for that alone, the length of it, sole child care provider for young children, etc. Thus, when considering the prejudice in Latah County demonstrated in Dr. Edelman's survey and the population size of Latah County together, the court is concerned that if venue is not changed now, it will be asked to consider its decision during jury selection, which, if granted at that juncture, would very likely result in the trial being delayed many months. So doing this now prevents a delay in the future. Considering the undisputed evidence presented by the defense, the extreme nature of the news coverage in this case, and the smaller population in Latah County, The defense has met the rather low standard of demonstrating a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. 2. Convenience and interest of justice. Even without a finding of presumed prejudice, venue in this case must be changed for the convenience of parties and witnesses and in the interest of justice. While this issue was summarily addressed by the parties, the court had considered the logistics while the motion for change of venue was pending. While Latah County's court staff and court security are ready and willing to facilitate this trial to the best of their ability, there are serious issues that cannot be resolved no matter how much planning and preparation is done. First, and perhaps most important, is the issue of safety and security for the parties, witnesses, victims, families, jurors, and the Latah County community. The Latah County Sheriff's Office, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial while also continuing to perform their day to day duties of patrol and responding to calls. One solution is to ask the Idaho State Police and Moscow Police Department to help. However, officers from both ISP and MPD are heavily involved with investigating the homicides, and it is anticipated that several officers will be called to testify at trial. Additionally, it is the court's understanding that both of those agencies are currently understaffed. Pulling local officers away from their normal duties for 3 months to provide trial security would potentially put the Latah County community at risk. Further, in the event of a natural disaster such as a wildfire or a large emergency, like an active shooter or a multi vehicle wreck, there is a very real possibility that officers tasked with trial security would be pulled away to deal with other issues. So, even if they were able to staff the trial with security, if an emergency situation were to happen, they would have to be pulled away from their where they were, whatever their duty was, um, as security detail for the trial. So they would have to be security would be no more for the trial once some kind of emergency takes place because they just simply don't have because the community is so small, they just don't have the number of staff. Thus, while our local law enforcement is ready and willing to do what they need to do to ensure a safe trial, there are not enough officers to ensure the safety of the parties, witnesses, victims' families, jurors, and community for a 3 month period. Similarly, Latah County does not have enough court clerks to efficiently manage the jury selection process. It is anticipated that general qualification questions will need to be sent out to some 6,000 individuals. The court clerks will be tasked with then entering juror information from those 6,000 individuals into an electronic system. Sorry, I don't know why words are getting mumbled and jumbled in my mouth. Blah. This task alone will require several clerks and will take time. The Latah County has only one clerk currently familiar with the process, and she has several other day to day responsibilities outside of her role as jury commissioner. Thus, to accomplish this task, Latah County would have to bring in clerks from other counties to help, along with extra equipment for those clerks to perform their work. So even if they had it in their county, they still need out of county help because they just don't have the capacity in Latah County to do such a big, long trial and with such a high profile um, nationwide, too. Where was I? So, extra computers. All right, so after the initial process, the court would summons in some 1,800 individuals to file or to fill out extensive jury questionnaires. Again, this process would require both court clerks and court security to take attendance, manage and move the individuals where they need to go to fill out questionnaires in privacy, scan questionnaires, and quickly get the questionnaires to the court and counsel. Again, while Latah County Court staff are willing to do what needs to be done, the reality is that we do not have enough individuals to perform the task of jury selection effectively and efficiently. Let my dog needs her blanket. All right, there we go. She was just caught in it. Further, the Latah County Courthouse itself poses significant issues for a trial of this length and magnitude. The courthouse lacks the space needed for both state and the defense. While the state had a dedicated space within the courthouse, the state would still be faced with the challenge of escorting sensitive witnesses through public spaces in the courthouse to get to the courtroom. Meanwhile, the defense does not have a dedicated space within the courthouse and there are limited options available. The few options available, i.e., the district court meeting room or a pretrial room, are small, located in public areas, and are not soundproof. These locations do not provide the defense with the privacy it needs during trial to meet with each other and witnesses. How do they have other trials at this courthouse then? Because he can't be the only defense witness or the defense defendant that wants to meet with his attorneys and witnesses in a private room. So where do they do that for other trials, I wonder? Further, the jury room itself is problematic in terms of its size. Fitting 12 to 13 jurors in the jury room for a routine trial is crowded. Fitting 18 jurors for the jury room for 3 months would be uncomfortable at best. Additionally, the door between the jury room and courtroom is not soundproof. Further, court security. So that's a problem then. That's not just going to affect this trial, that's going to affect all trials in this courthouse with a jury of 12 or 18. This isn't just unique to Kohberger's case. But, anyways, further, court security would be tasked with trying to bring the jury into the courtroom in a fashion that ensured the jurors' privacy while also ensuring the court's privacy. The only option for bringing the jury into the courtroom is through the public hallway or directly past the court's chambers. Neither are good options. How do they do it then? Further, there is also the issue of the continuing day-to-day operations at the Latah County Courthouse. The magistrate judge will continue to have daily hearings, a district judge will continue with the day-to-day operations of the court district, and the juvenile and CPS caseloads will have to continue. Additionally, the clerk's office must continue with its day-to-day operations of processing case filings, taking payments, and assisting the public. All these normal court operations will undoubtedly be strained by the resources required for this trial in terms of space and personnel. While traveling to another county for 3 months is indeed inconvenient for the attorneys, the court, some family members of the victims, and some witnesses, having the trial at the Latah County Courthouse would also be inconvenient in numerous ways, and beyond that, would present serious safety risks. Thus, the interest of justice requires that the trial be moved to a venue with the resources, both in terms of personnel and space, necessary to effectively and efficiently handle a trial of this magnitude and length so that the parties and the court can focus on the case and not on peripheral issues. Conclusion and order. Kohberger's motion to change venue is granted pursuant to Idaho Criminal Rule 21A and 21B. Consistent with the language of Idaho Criminal Rule 21C2B, the court orders the transfer of venue without specifying the new place of venue and refers the case to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another jurisdiction another jurisdictional district and assignment of a specific judge to preside in the criminal proceeding. So he's asking for the administrative director of courts to reassign this case, assign it to a proper judge who is in that county's jurisdiction. So he is granting the motion to change venue and asking for a new judge. He's like, I don't want to go several weeks out of my calendar and live in another county. So he's granting it, but he is also taking himself right out of being on this case, which is unfortunate because, like I said, I think he was pretty fair in most of his rulings and the way that he interacted with the attorneys. I didn't feel like there was a specific bias in any way. So, that is kind of what I think about that. So, it's kind of sad he's gone, but hopefully the next judge will be uh, as of sound mind and level-headed as John Judge was, because I think that's how he ruled. Very like take in all the info and process it, and then I'll make a decision. So, all right. So, what do you guys think the Gonzalez family thinks about this? Because as we know, the Gonzalez family always has something to say about something. So, they actually did come up with a statement, and this is according to an NBC News article. The Gonzalez family said Monday it was incredibly disappointed in Judge Gull's ruling. Let me make that bigger. They continue on saying the only good thing about this decision is it will be Judge's last decision in this case. The family said in a statement, adding, if the judge knew Latah County could not handle this trial for safety reasons, not enough court clerks, logistics, and lacking space, why did we waste over a year in a county he knew was not going to handle the trial? The points he mentioned didn't all of a sudden jump up and bite him in the rear. And that is what they think of Judge, the Gonzalez family. I don't know who specifically said it. They made a joint statement, I guess, Christy and what's his name? I can't think of Mr. Gonzalez's name. Steve and Christy. So yeah, perhaps they are not happy with Judge, and they're really not happy with the change of venue, is what I think, and they're really laying it out there. Which, they're very vocal. They like to express their opinions, which is great because we do like to hear from the victims and their standpoint, but it also can, I think, impede or hurt them, or at least hurt um, the case in general, public perception. Like, I don't think it was necessary to bash the judge and say that it jumped up and bit him in the rear or whatever, or didn't. Um, and the next judge is going to see that and see, like, oh, well, this family, they just like to speak out about public figures and they don't even care. So that could rub the judge the wrong way. It's just not a good thing to do. I understand they're victims. I get that. And I wouldn't be going to the media every time something happened and telling them my opinion if I was a victim or a family member of a victim, but that's just me. These guys like to be vocal and express their opinions. So, um, and good for them. They have every right to do that. I just wonder how much it hurts or helps them. I don't know. I don't think it really helps them a whole lot when uh, they've been very outspoken against Judge, and now you can really tell they did not like him, and they're glad he's off the case. So hopefully they get a better judge that they like. And I don't know. I don't know if that is going to really change things because there's still going to be rulings and things that the Gonzalez family probably won't like, unfortunately. But um, it's necessary for the interest of justice. We need to have, I think, a new venue. I mostly, for the most part, like maybe 85, 90% agree with the change of venue. There's like that little part of me that says, yeah, I get that the county itself that experienced that wants to get the justice for that. But in the same vein, that's exactly what the survey is trying to fight against. The people trying to get a vindication or revenge against the person that did this. And that's not what it's supposed to be. We're here to seek justice and truth. And I don't think that that would have necessarily happened in Latah County, especially when we have a lot of biases that we don't even know we have. And being from the county, maybe a cousin of a mother of a friend of a somebody you know works at the university or knew someone that was a friend of the victims, I mean, there's a lot of close ties in that town that I think it's beneficial for the larger population. It's just a pain in the butt for the family, the attorneys, cost more money for the state. It's going to be logistically just not fun to do for all the people involved, but I think it's the right call. And it's kind of sad, like I said, to see Judge go, but I get that he probably doesn't have the time to take off his schedule for 3 months to go to another county either. So maybe it's a good decision on his part. I'll miss the level-headedness of Judge, but what do you guys think? Let me know in the comments below. Excuse me. And please hit the like button on your way out. Let me know what you think about the change of venue. Should they or shouldn't they move to Ada County? Do you think it was a good or bad decision that Judge is now gone? Let me know your thoughts. Thank you so much for watching, and I'll see you guys in the next one. Take care. Bye now.